of Governor Machakos County failed the constitutional test of verifiability, and the declaration made by him that the third respondent was duly elected had no legal basis. Consequently, the learned judge erred in holding that that election was conducted in accordance with constitutional principles and Articles 81 and 86 of the Constitution. Finally, the appellants invited us to declare that the third respondent is not and was not eligible to contest in the 8th August 2017 Machakos gubernatorial election, having knowingly, it was contended, aided in the contravention of Section 15(1) of the Election Offences Act, contrary to Section 15(3) of that Act. Section 15(1)(a) of the Election Offences Act provides that a public officer who engages in the activities of any political party or candidate or acts as an agent of a political party or candidate in an election commits an offense and is liable to on conviction to a fine or imprisonment or both. Section 15(3) provides that a candidate who knowingly aids in the contravention of subsection 1 shall not be eligible to contest in the elections. In the case of Frederick Otieno Outa versus Jared Odoyo, the Supreme Court stated, we quote, "Election offenses are therefore quasi-criminal in nature, and the court ought not to enter a finding of guilt if the evidence adduced is not definitive and cannot sustain such a finding, or if there is any doubt as to whether such offense was indeed committed, or by whom. The commission of an election offense is proved, if proved, will not only lead to the election being set aside, but also to the disqualification of the perceived culprit from standing as a parliamentary election candidate, given the terms of Article 99H of the Constitution. The offender is also liable to criminal penalty under the Elections Act. In those circumstances, the person alleging the commission of the offense is required to prove the ingredients of the offense, and such proof of an offense takes a higher level than the mere preponderance of probabilities," end quotes. And subsequently, in Moses Masika Wetangula versus Muskari Kombo, the Supreme Court reaffirmed that very principle when they stated, and I quote, "The legal framework for electoral dispute settlement confers upon the court a quasi-criminal jurisdiction which is not part of the established criminal code, being derived from the fundamental elements of criminal law, which imposes strict penalty in respect of prohibited acts, and which is attendant with established trial safeguards. Such quasi-criminal offenses as are provided for in the electoral law, too, are required to be strictly proved as a basis for any penal consequences," end quotes. In his testimony, the third respondent stated that the recruitment of agents was a party affair undertaken by the chief executive officer of the sponsoring political party, and that he had no role in the recruitment. In our view, the evidence presented before the election court did not establish to the required standard, beyond reasonable doubt, that the third respondent knowingly aided in the contravention of Section 15(1)(a) of the Election Offences Act. We therefore decline to make the declaration sought that the third respondent is not and was not eligible to contest in the elections. We think we've said enough and exhaustively addressed the germane grounds in this appeal to show that this appeal is meritorious and ought to succeed. Consequently, we arrive at the conclusion that this appeal must succeed in terms of prayers 1, 2, 3, 6, 7, and 8 of the Memorandum of Appeal, with the result that the judgment of the High Court given on 9th February 2018 is hereby set aside in its entirety. We substitute therewith a declaration that the Machakos County gubernatorial election was not conducted in accordance with the constitutional principles, thereby rendering the elections void. We direct IEBC to organize and conduct fresh gubernatorial elections for Machakos County in conformity with the Constitution, the Elections Act, and regulations. As regards course, we have no reason to depart from the general principle that course follow the events. Consequently, the appellants shall have the course of the appeal as well as the course of the proceedings in the High Court, which shall be taxed. The appellant's cost in the High Court shall not exceed and are capped at Kenya shillings 1.5 million as against the first and second respondent, and Kenya shillings 1.5 million as against the third respondent. The appellant's cost of the appeal shall not exceed and are capped at 1 million shillings as against the first and second respondents, and another 1 million as against the third respondents. These are the final orders of the court. A. The appellant's appeal is allowed, and the judgment and order of the High Court given on 9th February 2018 is hereby set aside. B. It is hereby directed that the third respondent was not validly declared as the governor of Machakos County. C. IEBC is hereby directed to organize and conduct fresh elections for the position of Governor Machakos County in conformity with the Constitution, the Elections Act, and the relevant regulations. D. A certificate issued by the Elections Court pursuant to Section 86 of the Elections Act is hereby set aside and substituted with a certificate that the third respondent was not validly declared as having been elected as governor during the elections held on the 8th of August 2017. E. The first and second respondent shall pay to the appellants costs incurred before the election court to be taxed but not to exceed 1.5 million. F. The third respondent shall pay to the appellants costs incurred before the elections court to be taxed but not to exceed 1.5 million. And the third, that's G, the first and the second respondent shall pay the appellant's costs in this appeal not to exceed 1 million shillings. The third respondent shall pay costs of this appeal to be taxed but not to exceed 1 million shillings. Those are the orders of the court.
Thank you.
tradition of the election. You must ask yourself that question as the judicial. Because the press I think I would rather have. Thank you.